Good afternoon. Hello. Welcome to our webinar. Today's topic is what to expect when you are inspected. And today we are going to focus on primarily regulatory concerns in food businesses and what to expect if a government agent is going to visit your facility, whether in an announced or an unannounced fashion. I do see in the attendance list so far some friendly faces, some folks we know, maybe some folks we have not met yet, but I do want to introduce myself. My name is Brian Kellerman. I am the co-founder of Kellerman Consulting, as well as the Chief Quality and Safety Officer. We've been doing this for a little over 7 years. Before that, I was a QA manager, and in both being a QA manager and as a consultant, we've obviously interacted with many folks who go through inspection. For this talk, I do want to make sure that we emphasize that we're going to try to make sure we cover topics so that folks who have never gone through an inspection are going to learn quite a bit. But even if you've gone through an inspection, hopefully we're going to be able to talk about it in a way that helps contextualize and explain a little bit about what the inspectors are looking for, and maybe helps you get more prepared for the next one that you're going to go through. Real quick, and I like to mention this at the beginning of every webinar, there is a chat function on this presentation. If you would like to ask questions, that is my favorite part of webinars. If you go to our website, you'll find a bunch of training videos and things like that. And while we're very proud of what we do when we put up those videos, it's obviously something that people just watch and it's very passive. When we get to do a webinar like this, I'm here now. So if you type any questions into the chat function, I will try to stop and answer that question during the webinar. It really is something that I enjoy and allows it to be meaningful so that you are interacting with me while we have this discussion. So what we're going to talk about today, what we're going to cover, really can be grouped into two buckets here. Like what allows for these inspections to happen, and what are inspectors looking for to fulfill their obligation when they do an inspection. That's bucket number one. And then bucket number two is going to be what happens if a finding gets made. Now, for folks that are in a meat and poultry facility, if you are overseen by FSIS or in an arrangement similar to that at the state level, you may have an inspector in there every single day. So how you interact with them if a nonconformance report or an NR is issued versus what happens for facilities that may only see an inspector once a year or once every few years, and a finding is made, whether that's a 483 for an FDA agent or if it's a state level inspection finding. All of those things are somewhat handled in a similar manner, and so we will be looking at those. To break it down quickly, we're going to look at how to prepare for those unannounced inspections. We'll talk about announced versus unannounced and what that looks like. But then once the inspector's there, how you can expect they're going to behave, how your people in your facility should behave. Roughly, how do these inspections work? And while the inspections are occurring, what should you be looking for? What are the inspectors looking for? And what do you provide them? And then again, we'll talk about findings, how they're made, how you might interact with a certification body or a regulatory body if you have those inspections. And then to go along with that, how inspections are different than certifications for those of you who are familiar with GMP audits or GFSI audits. I do want to say before we move on here, and it's a thing I'm very proud of to get to announce to you, I am not a representative of any government agency. I speak only from experience. I have absolutely no connection to any of the inspection bodies. I do not speak for them, and nothing I say has anything to do with their own interpretations of their rules. I just know from experience. I'm also not a lawyer, so I have no legal advice to offer you. And in fact, we are going to get into the law, and I can tell you that I am just a lay person, never went to law school, and have no plans to do so. So with that said, as a non-lawyer, let's talk about the law. So the laws that exist in the United States And we're going to focus on the US. For those of you in other countries, you have to take it up with your country of origin and or residence and what their laws are. I don't know, but I can speak to US food laws. And I want to talk about the law very quickly here to point out that for those of you who have worked with me as a consultant, for those of you who have regulatory programs for either FSIS, FDA, your local or state government agency, you're not really interacting with the law. Okay, so I want everyone to understand the laws that are passed, those are passed in either your state house in the state that you live in or do business in, and also in Washington, D.C. at the federal level. Those laws are obviously passed by legislators, and they are instructions for how to build out the stuff that you deal with and the stuff that I deal with, which are regulations and the mechanisms of enforcement. So when we're talking about the inspections themselves, they are not actually going out there with a bunch of laws to interpret with you. And if any of you have ever tried to look up food laws, I'm sorry that you had to do that or that you accidentally did that, because trying to read it is pretty opaque and weird. The laws are written in legalese, and so they can be quite difficult to understand. But I want to quickly talk about, and I've listed here 4 laws that are very common. These are the sort of bedrock foundational laws that apply to most of our food businesses in America. And those laws, if you were to go read them, you would have a very hard time understanding what that has to do with your business, because most of the laws that are passed deal with setting up agencies and enforcing general principles of legal and illegal things. And of course, when an inspector comes, we are all very concerned about getting in trouble and having something be illegal. But the law itself doesn't necessarily address the specifics of how to run your business. They just simply say an agency with, and most of the laws deal with who are the agencies that are allowed to enforce the rules and how does the money get collected. So if you try to read it, you're really reading about like how are taxes collected and who gets paid and who gets to, if an inspector shows up from a agency that has jurisdiction, how do they behave? There's a lot in there about not bribing inspectors, right? So they are paid through taxation or through other means and cannot accept money from the business because that might be an act of fraud. And so the laws themselves just really are these sort of hermetically sealed, sort of like in a fishbowl set of documents that most businesses never address. However, what is very important for those of you listening to this is that when we want to think about how an inspector acts, they are trying to fulfill their obligation to these laws that you're probably not reading. And they do state the timelines by which things have to be reported. They do address the sort of basic behaviors of an agency and the kinds of bare minimum standards by which food is dealt with. So, for example, the Food, Drug, and Cosmetic Act, which is a very old law now, basically says the food has to be authentic and it can't hurt people. That's pretty much all the law says. But if you are somebody who's manufacturing, I think that there's someone who works at a dairy here. I know we have some bakeries out there. Your products can't kill someone, whether you follow the PMO, whether you follow a state law, whether it's the FSMA, the 21 CFR 117 requirements. You are following the guidelines and regulations of an agency to say this is how we're going to keep food safe, but really isn't the law, but how the inspector acts is, and what their motivation is to make sure that they are following the law as it applies to them every time they come into your facility. So what we experience is weirdness from inspectors. We try to talk to them, and sometimes they can answer our questions and sometimes they can't, and sometimes we understand what they're there for and sometimes we don't. But the reason is because they have a legal obligation to check a bunch of boxes, because if they don't do that, they might be breaking the law as it is established by the legislature. You as a food operator, whether or not what you're doing is right or wrong to the inspector, may come out in the inspection, but how they behave may not be clear to you. And I say that it's obvious when you see it, when an inspector will not sign in. So that is a frequent occurrence. Some of you may have had that experience. You have a sign-in sheet as part of a GMP or a GFSI program, and an inspector says, I refuse to sign in. Well, that isn't a personal opinion. That is because legally they may not, there may be aspects of how the law is administered where they don't sign because it may be an implication that they approve of something when a inspector is not allowed to do that. All right. So with that all said, let's talk about the reasons for inspections in general terms. And we are going to be talking about both announced and unannounced, right? So very quickly, you can have an announced inspection. Some of you may have already experienced that. If you need to get pre-approval at the permitting stage, when a business is opening, when equipment that is sort of flagged as potentially troublesome by a government inspector, they may say, call me when you install this and I will come see it. In that case, you have a scheduled inspection. Whereas most of us in the food industry are, waking up in a cold sweat at night. I have Rachel say that she had a health inspector refuse to sign a visitor policy. Exactly, that is a very common occurrence. So sorry, to get back into the types of scheduled and unscheduled audits, most of us are in a cold sweat because of those unannounced audits. Is an inspector going to knock on my door any day? And by the way, if any of you have ever been through a GFSI or a customer audit and the government comes in, that is also a relatively common occurrence at multiple an inspection that it overlaps an audit is fair game, and those government inspectors do not care. That is, again, the law says they need to go to every facility and see what's going on in their jurisdiction. And if they show up and something else is going on, like a GFSI audit, that means nothing to them. So we have here routine inspections and targeted inspections. And what a routine inspection means is that the inspector is walking the beat of their district. If you're in rural Indiana or Missouri or Arizona or up in Idaho, that inspector may have hundreds or thousands of miles in a jurisdiction. So they may be thinly stretched. Whereas if you're in a major metropolitan area, you may get an inspector every year, and they may have enough staff to really divide and conquer and really go around to businesses frequently. What we see at Kellerman Consulting, to peek behind the curtain, is sometimes it looks like government agencies are going around doing a big rush of routine inspections, because we will get phone calls from one state in which many people are calling us up and saying, hey, the government was just here. And it's like, oh, we can actually kind of like get a sense that they must be, walking the beat and knocking on doors and going inside, finding things that they want changed. A routine inspection means that they don't know why they're coming in there. They're doing it because they have a legal obligation. Again, back to the law, they have a legal obligation to make sure that they visit every facility. For those of you that have had state inspectors come in and say, hi, I'm from the state of Illinois or the state of Ohio, and I'm here on behalf of FDA, that's because the Food Safety Modernization Act requires that the FDA visit every facility annually. But there is not anywhere near enough FDA inspectors to go around. And in the regulation, it says that they are allowed to subcontract, but it also says in the regulations that the subcontracting is only performed by the state government. So you will have state agencies that are acting as as representatives of the FDA, so that the FDA is following the law. And when they come in, they may not ever even talk to the FDA. But when the FDA reports to the legislature as to the status of their following of the law, if all of the businesses, or if the vast majority, have been visited within the last year, they're meeting their obligation. And if a state inspector did it for them, great. That just checks that box. Conversely, we have our targeted inspections, and that is where there is something that is believed to be wrong about your business or a business, and the inspector is arriving to investigate. Now, if that happens, that means that there is already some sort of evidence elsewhere in the supply chain that there may be problems with this facility, and an inspector will unless there is some kind of catastrophic event, will let you know I am looking for something or this is a targeted inspection. Those inspections may involve mislabeling, misbranding, concerns over things like fraud or harm, or very commonly, folks who are operating outside of legal jurisdiction. This is really common for meat and poultry because, as those of you who have ever worked in an FSIS facility know, you have what's called a grant of inspection, which is a pre-approval process to manufacture. And there are businesses in America that are unaware of this requirement, and they may start making meat and poultry products without a grant of inspection, and the government doesn't know they're there when they start. So now I'm making beef jerky or sausage or whatever, and I'm doing that for months on end, and all of a sudden I get a knock on the door, and it's a government inspector. It's like, you shouldn't have been making any of this. You didn't get pre-approval, and now we're talking about getting padlocks on the door, and we're shutting it all down, and we're calling everything. Those would be a targeted inspection if someone found that product. And went to investigate. Lastly, and this is partially of a targeted investigation, there are helplines to the FDA, to state departments of ag, to health departments. Anyone that gets a notice that, hey, this business sold me something and I got sick, or there's a series of those that you get, a business will get put on the list, and an inspector will go out to respond to those tips or leads, and that would be an investigation. Now, obviously, that is a subset of a targeted inspection, but a targeted inspection largely will be involving something that they already know for sure, as opposed to a sort of investigation. Hey, I've heard some things and I just want to see what's in there. The difference between those types of investigations hopefully are fairly obvious as to the way an inspector may start asking questions. So, with that said, an inspector shows up. Hello, they're nice to meet you. Sometimes refusing to sign in accordance with your visitor policy. But they are going to come in. They usually, in my experience, come in with a brief, roller briefcase or a bag or something to house their computer and paperwork. And they will identify themselves and show you some sort of badge or equivalent, some kind of identification card. And they must do that. That is one of the issues that is absolutely required by law and by regulation, is that a government inspector performing an investigation must announce themselves and the purpose of that investigation. And if they fail to do that, that puts the whole thing at risk. So usually you should find nice compliance with somebody coming in and announcing who they are. And they may tell you what they are there for, or they may be vague about it, but they are going to announce themselves. Now, is that person going to be nice or not nice? Well, just like everything in life, it depends on the person. Certainly depends on the reason they're there. But the inspectors are generally, in my experience, either anticipating conflict or they are hoping for a compliant event. And they don't know necessarily what they're going to get until they get there. And so when they come in, an inspector may be very pleasant and may tell you, sometimes I have seen or am aware of inspectors coming, presenting themselves and saying, you know what, I'll come back tomorrow, which is a way of letting you it's taking an unannounced audit, but it kind of converts it to an announced audit. Lets you make sure you're okay, make sure you have your documentation. And there's nothing really wrong with that per se. Certainly if an inspector doesn't think that there's any cause for concern, they may allow that to be the case. If there's trouble, of course, they're not going to get the benefit of that doubt. So they will present themselves. And what are they looking for? So what they are looking for is much more like the police, right? So the reason for a regulatory or a government inspection is going to be looking for signs of illegality or signs of unclean or unsafe conditions. This is one of the main reasons why those of you who participate in GFSI or GMP audits are required to do so by customers. Because when the government comes in, they are not examining how good your product is. They are looking for signs that it might harm someone or that there is fraudulent activity. And when they don't see it and they don't give you a finding for it, if they just give you a report of a clean bill, entities want to provide that to their customers or clients to say, hey, look, I'm good, but that's a much lower standard than have I gone through an SQF audit and allowed an inspector to look, or an auditor to look through all my stuff. So as they're walking through, you can expect that they are looking for illegal acts that are things that are either in severe violation of regulation, so critical safety violations, which would become illegal if they use the word adulterated. That would mean that the product is inauthentic or harmful. And so things like toxic chemicals going in, whether intentionally or accidentally, into production lines, the use of pest control devices or substances that are, again, that would be hazardous inside of a facility may be deemed to be an illegal act. Receiving stolen goods, mislabeling, committing fraud. Those are the types of things that an inspector is looking for. Now, if they come in for a unannounced routine audit, they are not coming in expecting to find anything illegal. And you, as someone at a food factory, should be pretty well aware on a daily basis that your employees are not doing anything illegal, unsafe, or committing fraud. And an inspector certainly is going to be looking at you, if you are the QA manager or the person leading them around, just as awareness of like, yes, this is what usually happens, or this is not what usually happens. We are hoping for the fact that there won't be any conditions that occur on site that may trigger an illegal act or a violation of a regulation. However, as we said, the law isn't really at what's at play when an inspector is looking around. They're really enforcing the regulations. However, if they see something illegal, then we are talking about a whole other issue. The last bullet point here on this slide is something I just want to briefly mention, which is that they are also looking for things that they may need to report to other agencies within the government. So things like worker safety may not be in the FDA's main purview, but if they see something that's a violation of OSHA, they may either tell you I have to go report this, or they will just report it to another government agency. And that, again, is in compliance with a legal issue as much as a enforcing of regulations. If they see something, they got to say something. That's the slogan that we see in these modern times applies to people who may be running, using the subway in New York City, but a government inspector really needs to do that. And I do want to add here, the FDA, the FSIS, the state departments of ag, they are not really the police. And this is kind of an important point. It's a subtle one, but the FDA does not arrest anybody. FSIS does not, they don't walk around with handcuffs. And the reason for that is this, right? They are looking for signs of illegality, or they are enforcing the regulations for those agencies, but they're really people just like you and me. If they see illegal acts, if they need to bring in a policeman, they will actually either call a U.S. Marshal at the federal level, or they may call in the police, but the police are a whole separate entity. And obviously, we do not want the police being called by any food regulators. And if they call the police, then you're going to be in trouble with the police for legal issues. However, if an FDA inspector starts to write you up, you do not necessarily need to take your mind to, am I doing something illegal? Because they're not the police. They're simply creating a documentation trail when they see things that may be in violation of what practices they expect the facility to operate under. So, with that as background, we want to kind of look at what are the required documents for inspection. And required documents means two different things. The required documents are, what do you need to have for the inspector? And then also, what does the inspector need to have for you? Because you need to think of an inspection as a dance of sorts. And that dance has specific roles and responsibilities, and everyone has to play their part. The inspector owes you documents, and you may or may not owe your inspector documents. Now, I started in this industry prior to the adoption of the Food Safety Modernization Act, or at least prior to the enforcement of it. I started around 2015, and the law had been passed in 2011. It really had just been started to be rolled out in 2015 and into 2016. 2015 was for the largest companies in the country, and then 2016 it was in the smaller businesses. But before FSMA became enforced, the FDA really didn't have a whole lot of right to look at your documents the way that they would now. Only if it was a targeted investigation for the committing of a series of violations or crimes, then the government had the right to review your documents. But we were taught back then, if government shows up, take him to the shipping receiving office, show him the stuff that is related to crossing state lines. They can walk around, but you tell them to get lost. And you tell everybody, do not show the inspector anything. Well, FSMA changed all that. FSIS, that was not the case for as far back as I'm aware. They got to look at documents. The FDA gets to look at your documents. The state departments of ag, the health departments, if a government inspector is coming to your facility at this point in the current regulatory environment, they are allowed to look at your documents and records as they pertain to what they have jurisdiction over. And you need to have your records ready for them to look at, whether it be for what is being produced while they're on site. If they want to go back and look at things, again, if it's a routine inspection, that's what they're looking at or for may just show up. It may pop into their heads while they're talking to you. It may be based on your registration information. And so you may, they may be looking at a checklist and say, I want to talk about your pet food because you check the box that you have pet food here or something like that. If it's a targeted investigation, of course, they're probably going to come and say, I want to look at this product made on this day or this lot number because this is what we think is the problem. So at the start of the inspection, they're going to, again, identify themselves and show you official documentation. They are also going to start what is called a notice of inspection. Now, or at least for state or FDA inspectors, there is at the federal level what's called a 482. Those of you have may heard of a 483. We're going to get to that. The 482 is a notice of inspection. That is a document that is, again, to meet their legal obligation. It's the narrative of the inspection itself, regardless of whether there is anything bad, regardless of whether they want to make a finding, they still have to have an official report at the FDA federal level. That is a 482. For FSIS, the inspectors are basically there as part of the grant of inspection. And I honestly cannot even remember what the form would be for those official notices, but the inspectors are there. I don't even know that type of sort of general notification is applicable to meat and poultry. But certainly for most of you that are not in the meat and poultry, you should have either a state inspector giving you an official report or an FDA inspector giving you an official report. Then beyond that, if there are findings, and that's going to be based on walking through the facility or looking at your documentation, right? So they're going to start to look through maybe your food safety plan, supply chain control program, allergen program, you name it. They're going to go through shipping, receiving records, whatever they want to look at. For those of you, again, who have been through a GFSI audit, you know those sort of things. You don't go in the order of the GFSI book, but they're going to be looking for a lot of the similar things. They're going to be using their government manual to sort of evaluate and get guidance for themselves on what they're looking for. And they're going to inspect based on the rules. In a previous webinar, we talked about how to prepare for an audit and knowing the rule book. Well, for a regulatory audit, it's going to be their government rule book that they're using for their inspection. With any findings that are made, there will be a statement of those findings. And again, that is separate of the actual notice of inspection. So you get a report that says these are on this day, this person showed up and this is who they spoke to and this is what they looked at, blah, 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 all the way down. That's your inspection report. And that's one document that you must get from them. But then separately, if there is a notice of findings, that comes on a separate document and that triggers a whole separate interaction. So for those of you who have not yet been through a government inspection, you can be sure that you will get a report of that inspection no matter what. And if you get findings, that's going to be a separate document. And that is often a source of confusion, which is, all right, this person I got into some trouble with the inspector and he wants me to change what I'm doing. But then I also got this report afterwards and I couldn't understand why I got a report separate of this finding. Well, that's because they are two required sets of documents that you get. Now, and we're going to talk about how to clear up those findings later on in this presentation, but you will get from the government, whoever is with jurisdiction, they will send you letters, and those letters of correspondence are required from them, and they must clearly indicate to you what the issues are. And if you have responded, they will acknowledge the response. And we're going to get into that in a minute. Now, I have a question here, which is, can a facility exempt from a PFR registration due to direct sales to customers, which typically undergo inspection by health inspectors, be subject to visits by the FDA? Thank you very, very much for asking that question, because in the back of my mind, I felt I should have mentioned something about this. So when you are registering with the FDA, this is obviously something that happens with most businesses. Now, Nasim is asking about if you are exempt because you are mostly retail. If you're exempted from the FDA registration, but you have regular inspections by the health inspectors, then you probably are not going to get an FDA inspection. And unless the health inspectors have told you specifically, please register, I don't believe you need to register. But for this instance, Nasim, please, the next time the inspectors come in, if you feel like maybe you should, ask them. You're not going to get in any trouble, and in registering with the FDA is free. Now, I will tell you that registering with the FSIS, meat and poultry, is again a grant of inspection. You must reach out to the FSIS before you start. So there are no businesses operating without that. For the FDA, getting an FDA registration is literally the way that they know you're there. That is what FDA registration is for. It is from the Bioterrorism Act of 2002. And so it basically back now 21 years ago, as of this webinar, as I'm talking, that was basically a way to say, hey, we need to know who the food businesses are so we can properly regulate, so we can actually send inspectors in. And the fact of the matter is that if you do not have jurisdiction by the FDA, they probably don't even want you to register, but only because you are clearly known by a agency of jurisdiction. And we see this regularly at the state level, where a business only operates within one state and is very small. They may reach out to a federal agency and they say, hey, listen, if you're permitted and the state knows you, this is not relevant to us. Certainly for businesses that are exempt, we would expect that you do not need to register with the FDA, or even if you do register with the FDA, if they're aware of your exemption, they are not going to come and inspect. So that is one last fine point for you, Nasim, which is you can always go register with the FDA and identify yourself as exempt, and they probably won't even send an inspector. Just because they know you're there does not mean you automatically get inspected. But if you have registered, if you're required to register, you must, and that should lead to an inspection, because that's the whole point of the process. So let's talk about interacting with a regulatory inspector. So how are we supposed to talk to an inspector when they are there? And how long is this whole thing going to take anyways? So inspectors obviously have whatever time they feel they need to properly conduct an investigation of your facility. The bigger the facility, the longer they may be there. And certainly the more things that they have trouble with might make them stay. We have folks who get inspected for a week. An inspector may be there for a day or a small part of a day. So it can be any length of time. And there is no time limit. There is only an understanding between the inspector and the facility how long they need to be there, and that somebody who answers questions needs to be on site. The way the inspector is going to speak to you as the representative, or the way that you may have been spoken to, the inspector again is worried about making sure they are doing their job correctly. And the most important thing is that they cannot tell you what to do. And this is a huge issue for us as consultants, which gives us an incredible leg up on people who are government inspectors, at least as far as getting along with folks, is that when somebody asks a consultant what to do, I can tell you whatever I want. Now, hopefully I'm right, and I try very, very hard to give good, correct advice, but a government inspector cannot tell you what to do. And the reason for that is because if they tell you what to do and something wrong happens, and you go back and you're like, hey, I'm going to go talk to the newspaper, or I'm going to go talk to that government agency and say, your inspector told me to do this. Now it's on them. And that's not what they're there for. They are there to evaluate your facility for its, for the proper practices in the facility, not tell you how to run your business. This is obviously a huge frustration. Some of you may have had this in the past. A government inspector comes in and you're like, and they say, well, your allergens your labeling is wrong. Or more, I think a better one would be like, you're storing product incorrectly. And you say, well, tell me how to do it. The inspector is going to tell you, I cannot tell you how to store your product. All I can tell you is that it's wrong. And that is a incredibly frustrating conversation to have with someone, to be told both you're wrong and I can't even tell you why you're wrong. But the reason why that line of talk may occur is because an inspector is not allowed to do it. And that's, again, somewhat of a legal issue and a best practice issue, not just because they want to be jerks to you. Now, when inspectors are speaking, and those of you who have been through a certification audit know, or hopefully are vaguely aware of the most important pieces of being asked questions. And an inspector can go around and ask questions of anyone, same as an auditor might be able to. So an inspector coming in can target any employee for questions. Now, the people who are the head of QA, head of the company, can certainly be there and are allowed to sort of at least interject or offer up alternate answers if the person being talked to is confused. But an inspector will ask questions, and they will be open-ended questions, and they will be looking for the ability to get people to really start opening up and talking exuberantly about what goes on in the facility, because that is oftentimes where a untargeted, a typical, a routine investigation or a investigation based on a tip may lead to an actual series of events that they can find something that's wrong or what they're looking for. So they'll ask a question, and it might just be, do you like your job here? Or do you think it's safe here? Or do you know what your job is? And they can wait an uncomfortable length of time. And I know that we covered this in our internal audit webinar as well, but an open-ended question is a emotionally, as a human being, you kind of want to relieve the tension by continuing to talk, and that's bad. So we want to train our employees to stay calm, find your happy place, focus on your breathing when you're being talked to, do not get upset, no yelling, because that ain't going to help anything. And you listen to the question asked, you stay calm, and then most importantly, you answer the question as it is asked. So if a yes or no question is asked, there should be yes or no. Always sirs, ma'ams, that goes an awful long way, being calm and respectful. It is our position at Kellerman Consulting to be kind to your friendly inspectors and hope that they are kind in return. And remember that, yes, no matter how you feel about the government, one way or the other, no matter your political affiliation or anything like that, a government inspector has a job to do. They're there to do their job. And their hope and expectation is that you will provide them the information they need so that their job can be completed. This is not necessarily some sort of act of aggression just because you have somebody who has authority to look at your business and cast judgment, is just doing it to make you feel bad. And we highly encourage folks not to take that attitude, because it is often self-defeating. So we have about 20 minutes left, so we're going to talk for the remainder of this webinar about what happens if you get a finding, which is crucially important for folks who get inspection. This is what we're all worried about. And we're going to cover findings, and we're going to cover warning letters, because those are two very closely related but somewhat separate issues. So a finding of non-compliance with enforcement, which, for example, might be you do not have enough pest control boxes inside your facility, or there were an insufficient number of hand washing stations. I didn't see enough clear evidence of training. Any of those types of findings, it is not illegal, but rather your business is not meeting the standards of the rules and regulations of this of the agency enforcing. And so that can take the form of, again, for an FSI's facility, an NR, nonconformance report, a 483, a state level inspection. Whatever it is you've got, it should clearly state what the deficiency is. And so you should have that, and you're going to address every single one of those deficiencies. For those of you who have been through an audit, similar to an audit finding of nonconformances. When you are responding to a finding, and I cannot say this strongly enough, there are businesses that get findings, and for personal reasons, political reasons, whatever, they do not want to respond. That is absolutely the wrong way to handle these situations. Because if a report is made and findings are issued, whether they are in the initial finding or the warning letter, there are legal ramifications to the time limit by which responses are required. Even if you cannot do everything asked for in that time frame, responding respectfully and in writing is going to be the one way to make sure that you are not going to get into more trouble or any trouble potentially. And so taking these things seriously really, really shows the inspector themselves and the agency that they're going to be able to resolve this. And again, they're just doing their job. They want this thing done the way that you want it done. When they find something that they need corrected, their expectation is we're going to get this corrected. Obviously, folks who get findings are often quite ticked off about it. And so that anger can be a reason why we don't respond, but we should fight through that and not allow anger to cause us to fail to respond in a timely fashion. That's crucial. When we are responding, we are going to be talking briefly right now about corrective actions, preventive actions, right? Same as in an audit, same as any nonconformance that you might find in your facility. But with that nonconformance response, we're going to say what the situation is. So you should provide a root cause statement. This is why you saw this. Hey, sorry, our pest control guy, he's old fashioned and he didn't know the rules. So I'm getting a new pest control person. And that new pest control person is going to provide the documentation you were asking for, or will install tomcats and placards, just as an example. So we are going to explain to them how you fixed what they saw that was incorrect, whether it was right there when they were in the building or after they left, plus the corrective actions. These are the things that I'm going to do differently. I have new forms. I have a new program. I hired a new person. They're going to help me. And then the preventive actions, if those are different than the corrective actions, those all go to the government. And if you are able to provide that information, you should expect that they're going to close the book on that, on each finding that you do that for. And again, I will reference, if you've been through an audit and you've successfully completed an audit, which means clearing up nonconformances, then theoretically you should know what this feels like. That, hey, sometimes they may ask for more information, but if you're consistently answering their questions and moving fast, we should be able to get to resolution. If there are pervasive numbers of findings or an ineffective approach to resolving them, only then would we expect to see a warning letter issued. And those agencies that get warning letters, that is obviously far more significant than even any finding report. A warning letter is a tip-off that the government agency that is not the police, they are potentially going to be moving towards bringing in a legal entity. And let me quickly say here that my personal opinion on matters of legality is this, that when a government agency enters a facility, you're talking about people who are trying to do their job. One of the outcomes is the switching of the proverbial flipping a switch of the justice machine, as you will. And I use the term machine as an analogy, but once the on button of justice starts, there is no mechanism that can guarantee turn it off. And we do not want that. A warning letter is just that, a warning that they are moving in that direction. We want to intervene and intercede before anything gets passed on to legal entities representing the government, the Department of Justice, U.S. Marshals, anything like that. Because once that starts, they have their whole separate process. And as many people who go through the legal system learn, once that process starts, it ain't so easy to turn it off. You can't just say, oopsie, you got me. that doesn't absolve you of going through the whole process. And if a warning letter is issued, now we may actually bring in a lawyer. You'll notice up till now, for those of you who have been paying attention to this webinar, I have not mentioned lawyers except to tell you that I'm not one. But it is only like when you have a government inspection, or whether you're putting your food safety documents together, you don't necessarily need to go to a lawyer, because we don't deal with the law. We're dealing with, again, enforcement regulations. When a warning letter is issued, well, now I might need to go talk to a lawyer, because if there are legal issues, if the system of justice is about to be triggered, you better believe that one or many lawyers are going to be involved. We don't want that. So the actions taken for a response to a finding in an NR or a 483 or a state level, we want to address those immediately, so we're not issued warning letters. But if a warning letter is issued, we're definitely going to give root cause analysis, corrective actions, corrections, corrective actions, preventive actions, to sufficiently address every single item that was put on that warning letter. And they can be extensive. Now, I will say that, and this is a very important issue, when you respond to a government agency, that government agency does not give you the thumbs up. So if you have received a regulatory interaction, a NR, a 483, just a finding, or if you've been issued a warning letter, in both cases, you have to respond in writing, and so you must do so. And by the way, any response needs to have the date on it and needs to be signed by a person in charge of the facility. But when you issue that and when you send it to them, they're probably going to come back and say, thank you, I am acknowledging receipt of your interaction, of your documentation. The reason why they say, thank you, I'm acknowledging it, is because that's their legal obligation to close the book on it, is when they get the response. They don't even, they will evaluate it for sufficiency up to them, but they don't tell you, you are done here. And I want to quickly say that the example I use for all my clients is, if you get a warning from a police officer, if they pull you on the side, off the side of the road and issue you a warning, did you ever get in trouble? It's hard to say, right? Because they have written down the interaction and they told you don't do it again. In that moment, they did not issue any fines or take action. But if you were to get in trouble a second time, the written record of the previous interaction, even if it was just a warning, now probably gets elevated. And so that's how we need to think about any findings or warning letters, is if I am able to address these issues promptly, then I'm just going to have it in a written record somewhere that this happened. And as long as I don't have a continuation of that, then I did not get in any trouble. It's just that they will never acknowledge to you, the case is closed here, or we loved your corrective action, or we thought this was wonderful or well thought out. None of it. They're just going to say, thank you, I got it. And that's it. And that can be very disheartening, or it can be very confusing, but that's their job. So to summarize on that, and to sort of end with this note for this webinar, is that the agency will acknowledge receipt of any of your responses. They are not going to provide guidance to you. They are not going to want to talk through what you've done and see how you're feeling about it or how upset you are. They do not care. They will let you know if you need to give them more information. So if you don't hear, I need more from you, if they acknowledge, we have receipt of this, I have no more questions, then you can interpret that as likely the resolution of this instance of getting a finding. If they want more information, they will definitely let you know. And again, under the guise of, hey, you should be responding quickly to this, and you should be prompt with them to show them that you're taking it seriously, you can and should expect to get to resolution. But again, if there's follow-up, continue to promptly address it. And the most important piece is that when you have resolved it, those are the things that we can be sure when they come back, they're going to be looking for evidence that the corrective action, preventive action made in response to a warning letter or findings are still in place. So they will be targeting that. Again, certification audits work the same way and under the same principle. which is that if you have a finding previously, that's what we're going to be looking at. And I will say that, to go back to state agencies representing the FDA for FDA regulated facilities, a state agent may give you a clean bill of records with just a notice of inspection, and FDA comes in. Sometimes it's the same year. Sometimes shortly after into the next year, they will have no idea of that state inspection, because it wasn't like when they say it's done on the FDA's behalf, it just means to check the box that an inspection occurred. And the FDA inspector may make a finding where the state inspector did not. Nobody cares. There is no like injustice in that. There is no hypocrisy. There is only the difference of opinion, difference of approach. And again, our job is to respond to what is being laid out to us, not argue with them. The state didn't think that this was a problem, so why should I treat it that way now? That's a losing argument in these cases. So that was about 50 minutes, 51 or so. I did want to open up the floor over the last few minutes to see if anyone had any questions or any information they were looking for. We don't have any handouts for this presentation. There is our brochure, I think, that you can download. However, we did not provide any sort of written thing to go along with this, as we usually do with our webinar, because frankly, it's too unwieldy to try to give resources for government inspection. I will say that this last slide is our team. This is up to date. So these fine people and myself are the representatives of Kellerman Consulting. If you get a government inspector and you need help with anything, obviously we can help. However, our hope is that, one, your government inspector is either a positive experience, or the inspector is nice to you and you don't have to worry about these things, or if you've dealt with them, that this was a reassuring bit of information. And Eric is saying he was pulled away, no worries, but what should our response be when an inspector refuses to sign a visitor policy? Well, so Eric, one of the things we went through is that you are going to be given a notice of a report of that inspection, which is why the inspector isn't signing in. If an inspector doesn't want to sign in, that's fine. And you can say, all right, I acknowledge you're not going to sign in, but you need to say to them, that's fine. I will make sure that I get a notice of inspection from you. Because at the end of the day, no inspection can take place without some sort of written record from the inspector themselves. And so that you can expect that there will be written evidence they were there. And that should be written up somewhere in your program. Hey, I had a government inspection on September 25th, and I have a report for that. That can be written elsewhere, and you can write anywhere you want that they didn't sign in. The inspector isn't going to sign in because there is an offhand possibility that it could be interpreted that an inspector signing in was some kind of acknowledgement that your way of doing things was correct. So they simply cannot sign anything or refuse to sign things. Your response should be, I acknowledge what you're saying. I will be filing your notice of inspection, and I will be making sure in my records that it acknowledges you, sir, are here, and this is what you're here for. So you're just going to want to speak to them and say, okay, I'm going to take care of this in a different way, but it's important for me to acknowledge who you are. Get their name, write it down. You can maybe see if you can take a picture of their license or something like that. They may not, I don't know how they would deal with that, but if they refuse to sign in, that's cool, but just make sure that you follow up with them in a way that makes you comfortable to get that information. Is there anything else that anybody had? I'm not seeing anything. I'm going to give everyone about 30 to 60 seconds left. And if we don't hear anything, I'm going to get you folks your 5 minutes back. I do want to thank everyone for coming and attending this. It is always a pleasure to get to speak to everybody. And if we can ever be of any help, please let us know. All right. That's it. Thank you so much. Take care.